Recently, a group of 3 persons who are the founding members of the Fairview School filed a petition to wind up the school on the ground of default in payment of debt and the act of directors who acted in their own interests, which appear to be unfair and unjust to other members of the board. The question arises in this case is whether the ownership of the operating permits issued by the Ministry of Education belongs to Ahmad Rus, who is one of the founding members of the school and also the chairman. Even though the permits were issued to Ahmad Rus as the chairman, but none of the group of 3 were shareholders of the international school. The same thing goes to the ownership of the asset of international school. So now, let's ask the public opinion regarding these issues. Hi, good morning, Miss. I'm Jing Chi and I'm the reporter from the Malaysian Times. Do you know the recent issue about the Fairview International School?
Yes, I heard that there was an issue between some of the individuals in the Parent-Teacher Association and the school management. They even wanted to close down, but luckily they're still operating now.
Do you think that the ownership of the assets and the permits belong to the group of 3 as they are the founding members of the group?
Although the group of people were founding members of the school, this does not mean that they have ownerships of the permits and assets of the school. This is because they are merely just a group of people that came up with the idea to form the school.
Alright, thank you so much for your answer, Miss. So let's see what is the opinion of another person. Hi, good day, madam. I'm the reporter from the Malaysian Times. My name is Jing Chi. Have you heard about the dispute between the Fairview International School and its founding members?
Yeah, I heard that there was a problem between the school management and the founders of the school and that they wanted to close the school.
What is your opinion regarding the ownership of the permits and the asset of the school? Should they belong to the school or the founding members?
I think it should belong to the school management because the founding members are only the one who brought up the idea to build the school, nothing more.
Thank you, madam, for your opinion. Here is the report from the Malaysian Times. See you guys next time.
A very good morning, everyone. Welcome back to the Malaysian Times, your one-stop news center that gives you extensive insight into important topics from a Malaysian perspective. Today, in our weekly legal segment where we discuss important issues in the Malaysian legal landscape, we shall be covering the landmark Malaysian case of Fairview Schools Berhad versus Indrani AP Rajaratnam. My name is Ashruti and along with my fellow colleague, Miss Siti, we shall moderate this session today. For today's segment, we have invited 2 very special guests that specialize in company law to shed some light upon the major principles laid down in this case. First is Mr. Ng, who is a professor of company law at University Utara Malaysia. He acquired his PhD in company law from the University of Cambridge and has over 15 years of experience teaching the intricacies of company law and corporate governance. We also have Ms. Fatin Farina, a renowned attorney specializing in company and commercial law. In her 10 years of legal practice, she has successfully won many high-profile cases and gained many accolades, the most recent of which is the Young Lawyer of the Year award at the Asian Legal Business Malaysia Law Awards 2020. Thank you so much for being here with us today.
Thank you, Ms. Ashwati and Ms. Siti for having me.
Thank you, Ms. Ashwati and Ms. Siti for having me as well.
Thank you so much. Now that we have gotten to know our guests, let's begin today's session. Before we delve deeper into this case, let me share with everyone a description of the facts of this case. This case consists of an appeal to the Court of Appeal in Kuala Lumpur, revolving around company law. In this case, the appellant was an international school named Fairview and was originally set up by the Parent-Teacher Association of the Garden School. Among the founding members were Ahmad Rus, P.S. Sundram and Dr. Ayu Malik, who formed the Pro Tem committee that had actively brought about the incorporation of Fairview Schools. None of the group of 3 were shareholders of Fairview, but the memorandum and articles of association reveal that its 2 subscribers were the wives of Ahmad Rus and P.S. Sundram respectively. Later, after its incorporation and under the chairmanship of K.B. Thuraisingham, a land at Bukit Belacan was decided to be bought to expand Fairview and put up a new school building. However, upon a change of chairmanship, this initial land that was purchased was deemed unsuitable for school building and was sold at a loss. Following this, another land was purchased at Bandar Wangsa Maju. However, Fairview could not cover the total purchase price and had to resort to a loan from Vitaria Berhad. A dispute arose among the Parent-Teacher Association members regarding selling the Bukit Belacan land and the affairs surrounding the purchase of the Wangsa Maju land. This resulted in a vote of no confidence against the board, causing the resignation of the chairman at the time, Ahmad Rus, as well as some other members of the board. P.S. Sundram and another individual were also voted off the board. P.S. Sundram had then filed a civil suit against Fairview, KB Turaisingam, and the board. A new board was subsequently formed and an emergency general meeting was convened to discuss the increment of Fairview's share capital and to authorize the sale of shares to College Damansara Utama, whereby the resolutions were passed with the required majority. The respondents then filed a petition to wind up Fairview under Section 218, subsection 1, Clause E, F and I of the Companies Act 1965. Fairview responded by applying to the High Court for a stay of the winding up proceedings. I would now like to pass the floor to Ms. Siti to initiate the discussion of this case.
Thank you to my colleague, Ms. Ashwati, for the brilliant explanation of the facts of the case. This is quite a complex case and there are several issues that arose in this case. Let's begin with the first issue, which is the ownership of the operating permits issued by the Ministry of Education and ownership of assets of Fairview. Mr. Ng, what are your insights on this matter?
Okay, thank you, Ms. Siti, for the question. So the Court of Appeal in this case refers the ruling made by the High Court that the permits and the asset were belonging to the group of three, who were the promoter, or in simple term, the founding members of the company, on the reason that the application made to the ministry was not made in the personal capacity of the group of three. However, as agents of an entire group of individuals from Parents-Teacher Association of Garden School, and they were not an authority unto themselves, as they were a pro-term committee on behalf of all the individuals who lent their support to the idea of the Fairview, which in this case the school formation, which they were only holding the office temporarily for the period of the company before the formation, and they were handed over to the official director once Fairview was formally constituted. Although the Mr. Ahmad Rose was named as a chairman in this application letter, it was only part of the requirements under Section 48, Subsection 1 of Education Act 1961, and the application letter was referred to the chairman of PTA instead of Mr. Rose personally, and hence Mr. Rose was just acting on behalf of the Parents-Teacher Association. Also, the provisional certificates given by the ministry were renewed each year with a renewal fees of 2 ringgit Malaysia was paid on the company name, which is the Fairview instead of the group of three. Whilst for the asset, the record of the account of the company show deficit, and the asset as belonging to Fairview and not to the group of three. Thus, due to these few reasons I mentioned above, it is self-explanatory that the permits and asset belong to Fairview instead of the group of three.
Thank you, Mr. Ng, for your insight on the difference between the Court of Appeals and High Court's ground of judgment on the ownership of permit issued by the Ministry of Education and asset of Fairviews. A question to you, Ms. Fatin. Mahadev Shankar JCA, in his judgment on behalf of the Court of Appeal, stated that promoters have a legal duty not to make any secret profit out of the promotion of the company without the company's consent, and also to disclose to the company any interest the promoters have in any transaction proposed to be entered by the company. What is your analysis on this statement, Ms. Fatin?
All right. Thank you, Ms. Siti. So the legal principle that can be analyzed here is that the promoters have a legal duty not to make any secret profit out of the promotion of the company without the company's consent, and to disclose to the company any interest to the promoters have in any transaction proposed to be entered into by the company, which is the landmark principle from the judgment in this case. Moreover, the duty to disclose secret profit may be discharged if the promoter disclosed the incidents in the memorandum, articles, or prospectus of the company to an independent board of directors or the existing and intended members of the company. If a promoter acquires any property for the immature company after the commencement of the promotion, he is presumed to do so as the trustee of the company, so that he must hand in it over to the company at the price he gave for it, unless he discloses not merely the profit he proposes to make, but also to inform the company of its right to call for the property at its cost price, as alleged by Mahadev Shaka JCA on behalf of the Court of Appeal. Hence, it will amount to a breach of fiduciary duty by the promoters if they buy certain property for the proposed company and later sell it to the company with profit, and the profit is not disclosed to the company.
Thank you, Ms. Fatin, for your intriguing analysis on the legal duty of a promoter. Moving on to the second issue for today's discussion. Mr. Ng, what are your opinions on the issue of winding up of the school under Section 218 of the Companies Act?
Okay, thank you for this question. And in my opinion, the judges' power which are provided in this Section 218 of the Act are discretionary, and they have used their views of justice in interpreting the provision. So in exercising their discretion, they were very strict in granting the order to wind up companies, as they impose various conditions such as public interest, to apply other remedies before petitioning for winding up, and to apply winding up as the last resort. So subsequently, the crucial question here was whether the new board of the Fairview that mentioned by you just now had acted in their interest, which they thought would benefit the Fairview and the shareholders. So the trial judge of High Court had failed to consider the views of the shareholders and creditors which opposed the petition, and the fact that the special resolution passed on 28 November 1994 had a support of at least 75% of shareholders present and voting. Therefore, the petitioner's case under Section 218, subsection 1F, the Act was a non-starter. Besides, the Court of Appeals finding that the Fairview alone was the beneficial owner of all its assets and permits and negated there was a quasi-partnership existed. And the High Court view on to keep the school remains open and to neglect the non-compliance of Section 149, subsection 1B of Company Act 1965, which did not invalidate the policy, were wrong, and there was no evidence that the writer had acted in their interest. I think that's all for me.
Thank you, Mr. Ng. So building up on that answer, Ms. Fatin, how does the issue of winding up of the school under Section 218, subsection 1, clause F of the Companies Act differ from the issue of winding up under Section 218, subsection 1, clause I of the Companies Act?
This is an interesting issue. Thank you, Ms. Ashwati. In Section 218, subsection 1, paragraph I of the Companies Act permits the court to order the winding up if the court believes that it is just and equitable that the company be wound up and does not require the court to determine the existence of a partnership company. Isn't that, Mr. Ng?
Oh yeah, yes, Mr. Fatin. So the finding that the asset of the from Court of Appeal that the asset belong only to the Fairview must negate the suggestion that there was a quasi-partnership in existence in this case that I mentioned just now, and the court must not ignore the agreements between the parties which were reflected in the M&A, the Memorandum Articles of Association, in pursuit of what is regarded as fair. Moreover, in exploring ways to preserve the company as a going concern, far from terminating the company prior objective, the new board was seeking to perpetuate its existence. Also, the trial judge viewed that the non-compliance of Section 149, subsection 1, paragraph B of the Act did not invalidate the process was incorrect, and illegal practice cannot become legal by usage, and also the Section 149, the section means that what it says and must be complied with, and it was not right for the trial judge to hold it was just and equitable to penalize the Fairview when the board did precisely what the law required it to do. And there was also no evidence that the director had acted in their interest.
Yes. In addition, right, the Court of Appeal disagreed as the actual owner of the assets was concluded that the company alone was the beneficial owner of all its assets. Furthermore, the court observed three factors as decisive. the company was the sole owner of the company's assets. There was no express or implied partnership between the shareholders, and all the company's resolutions were passed with most votes prescribed by the memorandum and articles of association, i.e., the agreement between the shareholders and the companies at 1965. Implicitly, in the Court of Appeal, the court was very reluctant to grant an order based on the contention of just and equitable as the mere fact that every company must abide by the memorandum and articles of association, which will negate any finding of partnership relationship, and the petitioners have the burden to prove the prior existence of partnership or at least a relationship which substantiates a partnership. Therefore, the court may be less reluctant to make an order of winding up, as the court would take the consideration of equity in their duty towards the shareholders, and court will have more discretion to make orders which they think fit rather than to wind up the company, as required by the sixth section.
Thank you, Ms. Fatin and Mr. Ng, on the wonderful summarization and comparison of the issue of the winding up process under Section 218 of Companies Act. Let's take our discussion today to our third issue, which is the issue of multiplicity of proceedings. The issue is whether there were multiplicity of proceedings in both the Fairview's winding up petition and the civil suit filed by one of the respondents, P.S. Sundram. Mr. Ng, what are your take on this?
Okay, thanks for the question. And I think for the issue of multiplicity of the proceedings, the real context here in this case was between the group of three on one side and the Fairview and the educational authorities on the other. And the Court of Appeal ruled in favor of the Fairview, where there was some other ramification points arose, namely the ownership of the permits, the ownership of the assets of the Fairview, and the alleged illegality of the meetings on 11 and 17 November 1992, 7 March 1993, and also 28 August 1994. Even though Mr. Rose was not named as one of the petitioners in the civil suit, he howsoever embroiled himself in the proceedings, and hence the judgment must be equally binding upon the group of three. And estoppel would apply to them by the principle in the case of Nana Ofori Atta II and the case of Traders Sdn Bhd. Yeah, I think that's all.
Thank you, Mr. Ng, for the brief and very comprehensive analysis on the multiplicity of proceedings. On to our final issue of the day. Ms. Fatin, can you shed some light on why the Court of Appeal held that Fairview was not a trustee?
Sure. From the judgment, Fairview is not the trustee of the group of three. There was no provision in memorandum and articles of association stated that the Fairview's role was to act as trustee, and the owner of the assets of Fairview was the group of three and should be retained by the group of three. Even if Fairview is a trustee to a group of three, the group of three did not show the intention to bear the liabilities of Fairview in a land transaction. Other than that, if Fairview was trustee to the group of three, the assets of Fairview should belong to them, and there was no reason to hold company meeting to deal with this, with the asset in the company's books, such as decision of sale of Bukti Belacan land and purchase of land at Wangsa Maju. If Fairview is just a trustee to a group of three, the liability and obligation to pay PJK Sdn Bhd or repay the loan Bitaria Sdn Bhd would be the group's liability, and Bitaria Sdn Bhd could sue them for repayment of the loan. Since Fairview at all material time is a company, hence, upon its incorporation, it was a company, and therefore it is a separate entity and not trustee to the group of three.
Thank you for your explanation on our final issue of the case, Ms. Fatin. Before we end our session today, from the recent news, we understand that the Court of Appeal had some extra thoughts on the case. Could we know what they are? Maybe we can start with Mr. Ng and then proceed with Ms. Fatin.
Oh, sure. Okay, so basically the Court Court of Appeal had ratified 4 judgments of the High Court, such as proper course of action by petitioner, proper resolution for company issue, order of court under Section 221, subsection 1 of the Company Act 1965, and the cause of petition. So I think I will talk on the first 2, and the remaining 2 will be covered by Ms. Fatin. Is it okay?
Sure.
Okay, so the first one that I mentioned just now is about the proper course of action by the petitioner. So the Court of Appeal opined that the winding up proceedings should be dismissed because the proper course of action in this case to be initiated against the Fairview by the petitioner, the group of 3, would be by filing a civil claim in either detention or conversion, or even a declaration by way of judicial review in order for the court to declare that the property is being held on trust for them, instead of using winding up proceeding, which had misused the process of court and wasted time for the court. So while the second one is about the proper resolution for company issue, so the Court of Appeal also ruled that, especially in situations where 2 groups of shareholders are at war or matter in regard to company policy, the proper way is a way to resolve by the democratic process of majority vote instead of going to court proceedings. Yeah, I think, I will pass to Fatin, Miss Fatin.
All right, thank you. So the third is the order of the court under Section 221, subsection 1 of the Companies Act. So the Court of Appeal also mentioned that the High Court's decision in preserving the assets and the school as a going concern was completely misconceived, as the power given to the court under Section 221, subsection 1 of the Companies Act is only either order a winding up or dismiss the petition, while the power to deal with the assets of the company is vested in the liquidator. Moving on to the fourth is cause of petition. So the Court of Appeal also commented that the order by the High Court on cause of petition to be paid by the new director was misconceived, as the court should not make orders against a third party who was not the party to the proceedings and had not been heard, or why such orders should be made against him. So therefore, that's wrap up all the extra issues that brought out in the Court of Appeal in this case.
Well, with that sharing marks the end of our session today. Thank you, Mr. Ng and Ms. Fatin, for the analysis on the landmark case of Fairview Schools Berhad against Indrani Anak Perempuan Rajaratnam. With this, our legal segment for this week comes to a close. Stay tuned to next week's segment, where we will cover other important issues pertaining our Malaysian legal landscape. Thank you, everyone.